Hi, I'm Steve Lemon. I'm an attorney with Martin Hopkins and Lemon in Roanoke, and it's a pleasure to be with you to discuss some of the legal aspects you may encounter when considering granting a conservation easement on your property. One of the issues you may wonder is, why do I need a lawyer in this process? Well, the granting of a conservation easement is a complicated matter, and it involves placing restrictions and stewardship obligations on the landowner for an indefinite period in the future, forever. And so it's not something that should be entered into lightly. Counsel can assist you in the evaluation of the easement process, what rights and obligations you are undertaking, and help to craft the easement to carefully tailor the matters to achieve your conservation goals. Not every attorney is involved in the conservation easement area. In fact, it is a highly specialized area of law. When considering counsel to assist you with the evaluation of your conservation easement, you should ask him or her whether they have done conservation easement representation before. The attorney can assist you with a number of the aspects of the conservation easement process. The most important of these is the negotiation of the actual easement itself. The easement donee will normally have a form that is utilized in the negotiation of the easement. However, it is simply that, and the form needs to be carefully crafted to achieve the landowner's particular conservation goals. There is also a title search that is required to be performed, and coordination with the appraiser to make sure that he has the information he needs in order to complete his work. The attorney will assist with the recordation of the easement once negotiated with the clerk of the circuit court of the county where the property is located, and can also assist with filing and preparing the paperwork necessary with the Internal Revenue Service and the Virginia Department of Taxation in connection with the deductions and credits that can be associated with a conservation gift. There are generally 4 conservation purposes which are recognized as acceptable for a conservation easement. The first and least used is public recreation and education. This is the least used because it requires the landowner to allow the public to have access to their property. The second is protection of an important historic resource, such as a home listed on the National Registry that may be located on the farm. The third is protection of natural habitat for wildlife and fish. And the fourth and most commonly used is preservation of open space values for the benefit of the public. In order for this purpose to be used, it must be pursuant to a clearly delineated governmental policy and for the public good. An example of this would be property located in the viewshed of the Blue Ridge Parkway, so that its protection will enhance the driving experience. When it comes to real estate, lawyers like to talk about a bundle of twigs, bundle of rights, or jar of pencils. We do that predominantly to confuse the client. What we're talking about there is the various ownership rights that you have in property. Included would be possession, the ability to sell, the ability to let someone else come on your property. In the conservation easement area, what we're talking about is development rights, the ability to divide the property in the future. What buildings can be placed on the property? How will we protect the riparian assets? All of these are rights which the landowner has and can place in a conservation easement for the benefit of the public, stating what they can and cannot do with the property on a going forward basis. If you're watching this video or you're considering a conservation easement, you obviously have a conservation goal that you would like to achieve. These goals are turned into reality through the crafting of a carefully drawn conservation easement. Your issues may differ from those of your neighbor, and a primary role of counsel in the process is to assist you in achieving your particular goals with respect to the conservation of your property. So if you have particular ideas on how the timber will be cut on the property in the future, we will work with you to make sure that the easement as it is written allows what you want to allow and prevents what you want to prevent. Conservation easements often cover a number of particular areas. That would include division of the property, what structures can be constructed on the property, how riparian or water assets will be protected, such as exclusion of livestock, cover over the stream, and things of that nature, that trash will not be accumulated on the property, and how land disturbing activities will be handled. It is important to note that mining, surface mining, cannot be allowed on property encumbered by a conservation easement. Other items that will be discussed are enforcement rights, inspection, and other aspects required to complete the negotiation process.